So this will be on 675. There have been lots of talk and amendments and such, and I'm hopeful that we have all come to a really nice conclusion on this, but we shall see, I guess. So, Representative Glorioso, on your bill.
Thank you, Mr. Chairman, Senators. This bill I was asked to carry on behalf of the Attorney General, and the goal of this bill is to bring justice and finality to victims of crime and their families, to cure certain abuses in the post-conviction relief system, to set reasonable deadlines, and to create finality for those families. I do believe we have some amendments. I don't know if staff had an opportunity to complete them too. If it pleases the chairman, can we take those up?
Certainly, the staff will be passing those out. Does the representative have a copy?
Yep.
Okay. Okay, we have in front of us Amendment Set 2683. Representative, I assume you asked that these be prepared?
That's correct, Mr. Chairman. I'm looking at them. Most of these amendments are the result of work that we have been working with all of the stakeholders, the District Attorneys Association, Innocence Project New Orleans, and other stakeholders to correct some language, provide some clarity in the bill, primarily related to the deadlines that were being changed so that the dates matched, that the prospective nature of the bill was appropriately scheduled, and it is believed mostly clean up and making sure that the intent of the bill was properly carried out in the language of the bill.
Okay. Just looking through it, a fairly significant long amendment. Most of it looks technical, but you're deleting certain sections, and
a lot of it, Mr. Chairman, deals with the timing, and so because we were shortening some of the times, and then there were changes in what happens if someone pleads guilty. Those we wanted to make sure, it was always our intent to make sure those were prospective only, and that anyone in the system would have proper notice in advance. And so we work with the Innocence Project New Orleans and some other groups to adjust those so that it was in the proper posture. They are procedurally technical amendments, but that's the gist of the amendments.
Okay, Senator Barrow, is your question on the amendment?
Yes, it is.
Okay, Senator Barrow for a question on the amendment.
So I'm looking at these amendments, trying to digest them really quickly, but amendment number 17, if you could provide further explanation on this one, I would greatly appreciate it. Amendment number 17 is number 7 on page 2.
You want to do that one?
If I may, Mr. Chairman, Larry Freeman, Chief Deputy Attorney General. The gist of that amendment, Senator Barrow, is that the Attorney General will get notice of a filing of a post-conviction relief if the district attorney waives or does not raise procedural objections. That allows the Attorney General time to intervene into that matter to decide whether or not there are procedural objections that can be raised. So the way it's worded, it says if the district attorney waives or does not file procedural objections, then the Attorney General will get notice from the of that particular filing. So that's what 17 is addressing.
Okay, it's I'm trying to see like what is that timing, and I'm trying to see is it. I guess it may be outlined in the bill here. I'm just trying to make the connection
Yes,
really
ma'am.
quickly. Oh, it's the wrong page. What is that timeline?
The notice.
Notified within.
Yes. It says the response, if you go further, the response shall be provided to the Attorney General concurrent with the filing. So if the DA either affirmatively waives, which they're not actually allowed to do under the law, or raises no procedural objections, which could be considered a tacit waiver, then they have to provide a copy of that filing to the Attorney General at the time they file it. Then the Attorney General will have 30 days to then raise any objections that the Attorney General may have if they're not utilizing procedural objections that are available.
Okay. That's all the questions I have for now, Mr. Chairman.
Senator Abram, your question on the amendments?
Yeah.
Okay.
I'm just picking out a few things here just to
Yes, sir.
understand. Amendment number 21 on page 10, the beginning of line 14. Now, the re-engrossed version, if I'm understanding it, you already made it go from 2 to 1.
Yes, sir.
Now you're going back to 2.
Yes, sir. Let me tell you what behind that. The Attorney General talked to Dean Landrieu at Loyola, who handles a lot of the capital cases, and Dean Landrieu said that they can move some of these cases in the time frame that's in the engrossed version, but they couldn't move all those cases that quickly. So they came to an agreement to extend the current petitions from 6 months to a year, and then the ones that are newly filed from 1 year back to 2 years, to give those more time for people to be able to respond and do the things they need to do. So it was a compromise that we made with Loyola Law Clinic to try to give them additional time to handle their cases.
No, that's fine, and that's a good explanation. It's just, in this body, I don't know how many times I've heard, well, we need to shorten the time before we can do, or we need to lengthen. We go back and forth on deciding
my good
if it's a
friend
shorter
next to
time or
me
longer time.
did shorten the time, but we had to make a compromise to put it back to where it was.
All right, amendment number 27, I guess it's the same sort of thing, page 11, line 7
Yes, sir.
to
That
10.
deals with the time limit, just like the others.
Okay, now you're pushing that one, you're shortening that one back to 2 years, right?
Well,
It
no,
was-
it's 2 years. We were.
Originally it was 3 here, you scratched
Right.
all of that out, right?
It's consistent with the 2-year time
2 year,
frame.
okay. Did he already propose this amendment, set of amendments 26, 22, or not yet? We still
no,
on just?
no, we're
Okay,
on
all right. That's all the questions I
2683.
have on 2683. Thank you.
Okay, I'll offer up this set of amendments. Is there any objection to the adoption of Amendment Set 2683? There being none, that set of amendments will be adopted. We have another set of amendments, 2622. Representative or Mr. Freeman or Mr. Walters, if you would explain this amendment.
Yes, sir. Again, Larry Freeman, Chief Deputy Attorney General. This amendment is to be consistent with the funding that has already taken place. The public defenders needed an additional $4.2 million, I think, available to handle these capital cases. And I believe the Senate has put that money into the budget and placed it into the Louisiana Public Defenders Fund. So this amendment addresses where the money's going and how they can access that money on an ongoing basis. It puts some guardrails and some conditions for them to come get the money through JLCB when they need extra money going forward.
Okay, I think that explains it. Senator Abraham has a question.
Yeah, and I know we're not Senate Finance, but basically what you're saying is this probably will not have to go to Senate Finance because the money is already there.
Correct.
And that way you can go and attach it. But it also says that if it's not there, what does it say? Okay, if it's not there, you can request supplemental funding on a case-by-case basis from that fund. Okay.
Well, yes, it's that if they have insufficient funds to move the cases, they can come back and access the money that's been allocated to that fund. It's not going to go the way normally the funding goes for the public defender is they give them a lump sum, and then the public defender doles it out. This is putting the $4 million into this fund controlled by the legislature, and then they have to come to the legislature to get it as needed.
And the Public Defender's Office is okay with this?
Yes, we haven't heard any complaints from them on that.
Okay, thank you.
Okay, Senator Barrow for a question.
So that then brings up a question, because I certainly have worked very closely with the public defenders, and so it's interesting if they not come to you guys and have not said anything. But in the event, and God forbid, but in the event if there is no funds in this fund, what happens?
the cases will stop. The courts will control that. If the public defenders have no more money to defend the cases,
And they
the
cannot-
cases stop.
Okay, and they cannot be properly represented.
Correct. They stop. The judge will stop the case in its tracks until they get sufficient funding to continue forward. So they won't be allowed to go forward without proper representation. And the
Okay.
judges will control that.
Okay, because that has always been a concern. They always kind of struggle most of the time to have enough money to be able to represent individuals, and so. Okay, thank you.
Thank you, Senator Barrow. I'll offer up a set of amendments 2622. Is there any objection? Being none, that will be adopted. We have some cards in support. Larry Freeman, Chief Deputy Attorney General, who's at the table. Chris Walters, Deputy Executive Counsel to Governor Landry, in support, who's at the table, can answer questions if needed. In support, not wishing to speak, Billy Joe Harrington, he's the DA in the 10th JDC, and Darren Alamon, who's present. In support, he's with the Jefferson Parish DA's office and will provide information if requested. There is a white card from Tiffany Simpson with the Office of the State Public Defender, is here to answer questions if requested. Are you requesting? Senator Barrow would like, so if you all would clear the table so Ms. Simpson can come and answer some questions.
Hello, Ms. Simpson.
Good morning. Good afternoon, I should say.
It's been a while since I've seen you.
Has been.
Yes. So, just tell me. I was a little shocked to see that you guys did not have. We're not coming up this kind of state the impact that this could possibly have on the public defenders, but.
Well, I will say, Tiffany Simpson, Office of the State Public Defender. I have a message to the State Public Defender because I was unaware of the amendment that you all just approved, and he just told me that it's something he's never heard of. So the process that I haven't seen the amendment, so I don't even know what it looks like. I just know what was indicated just a few moments ago. But neither myself nor the State Public Defender have ever seen this amendment, so I can't tell you what issues or concerns we would have with it because we've never seen it before.
Why don't you take a look at it? It's pretty simple. It just says you got to go to joint budget to get approval to disburse money out of that fund to pay for
So it seems
to pay
like
for
this.
capital defense.
Yeah.
So I would, again, also trying to make sure I understand the amendments that were passed earlier, and really hard, it's hard to kind of put everything in line looking online, but I would imagine if there's a time period for which we want all these cases to be handled, if we have to then go to joint budget to get approval to spend the money, then that will slow us down. We will not be able to move as quickly as you all would hope if we have to get approval from joint budget before we can spend funds.
Right. But, it's state funds, so we kind of want some guardrails. So
We'll do whatever you want us to do. That's
you
absolutely.
could wait till the legislature appropriates it, but you'd have to wait a year maybe, but joint budget meets at least once a month.
So on Sunday, the $4.1 million was added to our budget for 26. And then, so this is news to us about having to go before joint budget. But again, we'll do whatever it is the legislature tells us to do. That has always been the state public defender's perspective on things. I just want to say on the record that if we don't just get the $4 million and can allocate it as needed, if we have to then come to you all every time we get ready to make funds, that will slow us down.
I understand.
So based on, because this has never happened like this before, as I remember in the past, as you guys have been working on a case, you guys have just been able to have the access to be able to do that. So now, even if we didn't have enough money, we were able to actually, if y'all didn't have enough money in your budget for any particular case, you were able to still continue the case. You didn't have to stop. Am I correct?
So when it comes to capital, we pay the programs a set amount a month. And so they, within their budgets, have allocated, I think they each have 6 attorneys, the ones that handle post-conviction, they each have 6 attorneys apiece who handle post-conviction work. And so now it is, the way they staff is not contemplated that they would be trying to handle, 40 existing cases at one time. I believe they indicated to us that they, in total, between the 2 programs, I believe they could handle 12. So that was why we had the fiscal note, because we were saying we would have to increase the number of staffing, although most of this, we don't have people who can do most of this work. We do have a certification process that is going on right now to try and get additional attorneys to handle the work, but obviously it's a very specialized work that just,
Right.
Anybody wouldn't be able to do. So in the past, they've staffed at the rate of which cases play out. And these cases that do take a long time. I realize that's why we're here today, because these cases do take a long time. So they've staffed in that manner. So they're going to have to try to staff and try to handle more cases, and then also work around this of us having to go to joint budget to get approval to pay for what is coming up.
Okay. Thank you. Thank you, Mr. Chairman.
Thank you, Senator Barrow.
Any other questions?
We did have a couple of additional green cards come in late. Christine Russell, Louisiana District Attorneys Association, and Hiller Moore, the DA for Baton Rouge, 19th JDC. I thought Zach Daniels had tried to submit one, but we're not seeing it up here. So we do have several people who want to speak in opposition. So you might want to clear the table. Representative, we'll bring it up 3 at a time. Ronald Marshall from New Orleans, Washington Avenue, New Orleans. Cecilia Capel, Loyola Center for Social Justice, and Matilda Carbia with the New Orleans Center for Justice, if that's reading that correct. Lee, if you 3 would come up and give us your testimony. And we did get one from Zach Daniels, 675, in support, Louisiana District Attorneys Association. Yes, ma'am. Maybe we'll start going, whoever wants to go first, just pick.
I can go first.
Yes, ma'am. Please do.
Good afternoon. Thank you for hearing my testimony, Chairman Morris and members of the committee. My name is Cecilia Capel, and I'm here in my capacity as the director of the Loyola Center for Social Justice. I first want to say I truly appreciate the amendments. I think that they are very helpful to mitigate some of the issues that I plan to speak with you all about today, including pushing back some of the deadlines. I do think that it would be even more helpful to delay the implementation of the bill by a year, both to court staff, judges, and to district attorneys, as well as, of course, defense attorneys. So just a little bit about my organization. We are employees of Loyola College of Law. We represent a dozen people on death row. We represent men who are convicted and sentenced to death in their direct appeals and post-conviction proceedings. Our budget is $1,050,000. With that budget, we have 6 attorneys and 3 investigators. We have 0 admin and paralegal staff, and we share office space. Our staff works full-time. They are not allowed to take outside cases, and the public defender, the state public defender contracts with us to provide 1,700 hours per staff position. Now, we regularly go far beyond that to represent our clients because these cases require an extremely heavy use of resources and time. Our ability to ethically represent our clients with this budget relies on the fact that not every single case can be moving at the same time. So therefore, we have to basically have deadlines in some cases and not others. And this bill requires that all cases have to move forward to adjudication by this 1-year deadline. And it's not possible based on the staff that we have. We do not delay cases for the sake of delay. Our clients do not want to be on death row. They want their claims heard, and it is our job to zealously push forth those claims. In our cases, we request filing deadlines. Right now, we have 2 filing deadlines that we went into court and asked for. We are not being forced by the district attorneys or by judges. We are pushing these cases forward because it is our obligation to our client to push their claims forward. And finally, the delays that have occurred in these cases that are so-called delays. First of all, they're not outside of the norm. The mean time spent on death row in Louisiana is about 17 years. In Texas, next door, it's about 18 years. And nationwide, it's around 20. And so we are not an outlier in how long it takes to get these cases to resolution. In the past 25 years, since 2000, I think that people look at death row and say, oh, there's 55 people on there. What have we been doing for the past 25 years? Well, here's what we've been doing. We have adjudicated or resolved 70 cases. That means 70 people sentenced to death, not pretrial. And that is a massive amount of work. And that is what we have been doing in these cases. And I would note that 35 people sentenced to death in Louisiana have been removed from death row by negotiated resolution with the district attorneys. These are cases that the prosecution agreed should not be on death row. So the delays that have happened, everyone's been acting in good faith. The district attorneys are working hard. We're working hard. The court staff is working hard. But these things take time. Records take time to compile. As I mentioned in the other committee hearing, I have a DA file request that's been out since 2023, and I know for a fact the DA is working on compiling their file to give to us, but we can't move forward until we get the records, and we can't get the records until the cases are final, and these things just take years, and that's just how it is. And I want to end by saying, we have a ton of empathy for victims of crime in these cases, and I know that there's an expectation of finality and resolution, but the fact is, in capital cases, they just take time. And if victims want finality, the answer is a guilty plea before trial. The answer is a non-capital conviction. And that's the only way that we can have true finality for the victims.
Okay, thank you for testimony. We're going to take a short little deviation here. Senator Barrow wants to take personal privilege for just a moment, I believe.
Thank you so much, Mr. Chairman. I am so excited to see these individuals from my district, and this is my very good friend as well as constituent, and she has brought with her 2 granddaughters. So Tanya Selvage has brought her granddaughters, Casely and Corey. We all just kind of wave so everybody can see you. We want to welcome you all to the Capitol, and we're so glad to see them. So they're taking a field trip all the way from Texas.
Thank you, Senator Barrow.
Thank you.
I'm sorry, have you concluded your testimony, Ms. Capel?
Unless any of the members of the committee have any questions.
There are no questions at this point, but there may be in a moment.
Sure.
So if we can just continue on, please, ma'am.
Yes, thank you. Thank you, Mr. Chairman. I'm Matilde Carbia. I'm the director of the Mwalimu Center for Justice, and Ms. Capel has covered many of the points that I wanted to speak with y'all about today, so I will make this brief. But I just wanted to add on to give some context for the work that our organization does. We are the main post-conviction office in Louisiana for capital cases, and we represent the other 31 people currently in state post-conviction proceedings, and wanted to echo Ms. Capel's request for a one-year sunrise or on-ramp for the effective date of this bill to allow the system, and particularly the courts, to be able to prepare for the way that these deadlines are going to affect their own workload. And also wanted to express gratitude for the amendments that have already been considered and adopted by this committee, and happy to answer any questions.
At this point, the board is clear. So just for my own edification, each of your groups both handles post-conviction capital cases?
That's correct. My group handles about a quarter, and hers handles the other 3/4.
And the $4 million we put up is kind of split between you two, or that's going to be appropriated? Is that how that works?
I'm not sure how it's going to work, but we are going to work with the state public defender to allocate those funds.
I see. Are there other groups that handle post-conviction capital cases for indigents? Just you two?
Yes.
And do your attorneys are on staff? They're not contract attorneys?
That's correct.
Correct.
All of them, and they're all paid a salary?
Correct. And on average, our attorneys make around $49 per hour on average.
I see. Do they keep track of their hourly billing and
Yes.
that kind of thing?
Yes, we keep track based on 0.6 of an hour increments.
I see.
Yes.
Okay, just curious, and that's your internal management,
Correct.
because they're not charging it directly per case. It's
No.
Okay.
Everyone is salaried and not permitted to conduct outside work.
Okay. Thank you. And yes, sir. You are Senator Barrow has a question.
Yes, really quickly. So you guys are asking, in addition to some of the amendments that have been put forward, to have an additional year to actually delay putting this into law, so that you guys could have enough time to make those adjustments. Because I guess one of the things that I'm concerned about in listening and being a part of the public defender task force that we had a couple years ago is the level of work already. And what I'm concerned about is, with the shorter timeline, is maybe not on purpose, but errors that could possibly happen. And is that something that you guys see as a potential issue?
Absolutely. Yes, we see that as a potential issue. And also, as Ms. Simpson Dr. Simpson already testified to, each of our offices has currently 6 attorneys on staff. And as I testified in House Appropriations the other week, our office would need to triple our current staff in order to manage having all cases active at once, which is effectively what this bill is asking us to do. So, and we're happy to comply with the law, given that it's funded. And also, there are not triple the number of lawyers that we have available for immediate hire to jump into these cases. It's going to take us time to recruit, hire, and train. And also, as Dr. Simpson spoke about, there is a state certification process for handling capital cases that any folks joining our organizations would have to comply with.
I think that is a reasonable ask, and because I'm really concerned. I mean, I'm familiar with a lot of the issues that the public defenders were actually having in terms of getting enough attorneys because they are not paid this enormous salary, the workload that is placed upon them, and now it looks like it's going to perhaps double in some instance.
Yeah, Senator Barrow, I have a concrete example of what happens when we rush things and we understaff things. Jarrell Neal, his case was in Jefferson Parish, capital case, went through post-conviction proceedings in record time with no hearing on the merits. Things got missed. There was DNA evidence that exculpated him, and the federal court had to grant relief 25 years later. And so now we're pending a new trial in Jefferson Parish, and these things could have been taken care of at the district court level and state court if they had been done right.
Okay, thank you. I share y'all concerns, and I am concerned. Thank you very much, Mr. Chair.
Thank you, Senator Barrow. Yes, sir. You're next, please.
Yes, I appreciate. My name is Ronald Marsh, and I appreciate y'all allowing me to speak. I understand I have some amendments to the bill, so if my comments may have been carried by those amendments, just disregard my comments. Page 4, lines 9 through 12, guilty pleas and innocence. That part says that anyone who pleads guilty can't later claim innocence in a post-conviction filing after August 1st, 2025. That's deeply troubling. We know many people plead guilty even when they're innocent because they're scared, pressured, and poorly advised. That doesn't mean they actually committed the crime. This bill says you plead guilty, so too bad. Even if you have DNA proof or a confession from someone else, you cannot challenge your conviction. That's not just wrong, it's unjust. It locks innocent people into convictions they never should have had. Point 2, page 5, lines 2 through 4, attorney-client privilege. Another concern is around attorney-client privilege. This bill says that if someone raises a claim of ineffective assistance of counsel, which is the claim that most people raise on post-conviction, is ineffective assistance of counsel, they automatically waive attorney-client privilege over anything the state says it needs to respond. Attorney-client privilege is meant to protect people, to make sure they can speak freely to their lawyers. It's not supposed to disappear just because someone says their lawyer failed them or they file an actual ineffective assistance of counsel claim. Even the deputy director from the Attorney General's office just testified today on House Bill 64 that only a client can waive that attorney-client privilege, yet this bill does it for him. This could discourage people from ever speaking up about bad lawyering, especially if it means the private things that shared in trust can now be used against them. Point 3, abandonment of application. This part is on page 7. This part of the bill says if anyone doesn't take legal action within 2 years of filing their post-conviction application, their case is abandoned and can be dismissed. But most incarcerated people don't have lawyers. Many are shuffled between facilities, locked down, or denied access to libraries or legal support. How are they supposed to keep a case moving? What's worse, the courts doesn't even have to notify them, incarcerated people. The DA or the AG can file a one-sided motion and the court can dismiss the case without hearing from the person at all. And for people with a shell petition on file by July 1st, 2025, they'll have just 180 days to turn into a legally detailed argument, something most can't do without legal help. This provision punishes people for being poor, unrepresented, and locked away. And my last point, page 10, lines 7 through 9, suspensive appeals. This bill gives the DA and the AG the right to file a suspensive appeal if post-conviction relief is granted. This means even if a court finds someone wrongfully convicted, they stay in prison years later while the state challenges it. So even after winning in court, a person could be stuck in prison for months or even years waiting on the state's appeal. It's a clear imbalance. The state gets extra chances to delay justice, while the person who suffered a wrongful conviction faces tighter and tighter deadlines. In closing, House Bill 572 would not bring fairness or clarity to the system. It would do the opposite. It makes the path to justice harder, silences people, and closes the door on wrongfully convicted, especially those who are poor and unrepresented. I urge you to consider the real-life impact this bill would have on people and families across Louisiana, and respectfully ask you all to vote no on HB 572. Thank you.
Thank you, sir, for your testimony. If you all would clear the table, we've got some more people that would like to testify in opposition. Tim Boren, or Boyer, or Boren, Megan Garvey, Criminal Defense Lawyers Association, and Gary Clements. If the three of you all would come forward and testify.
Very fast, so.
Gary, you want to start?
We're doing
Ms.
ladies
Garvey,
first.
you want to start?
Thank you, Chairman. My name is Megan Garvey. I am the legislative chair of the Louisiana Association of Criminal Defense Lawyers. I am also a career public defender. I do not practice post-conviction litigation, and that is not my area of expertise. However, I just want to echo something that I believe you all have heard from a few of the other witnesses and some concerns that Senator Barrow brought up about the possibility of delayed delayed implementation for this bill. This bill proposes quite an overhaul to many aspects of the system because the same judges that are hearing the pretrial cases, hearing the trials, are going to be having to kick into high gear to figure out how to staff up and how to comply with a lot of the new deadlines here. I am concerned as a public defender and as a representative of the defense bar that without the delayed implementation, there's going to be chaos that is going to trickle down to pretrial cases, keeping people in jail longer, postponing their trials longer while judges try to get on top of all of this. So I would just ask that the committee would consider that delayed implementation. Thank you.
Thank you. I believe that was in the amendment, but in any event, yes, sir, if you could go next, please. The board is clear. Whoever wants to go.
I'll start. My name is Jim Boren. I'm a lawyer in Baton Rouge, Louisiana, and have been a criminal defense lawyer since 1976. Justice Knoll, when she was on the Louisiana Supreme Court, was concerned about the length of time that it took for capital and non-capital post-conviction cases to make it through the system. And so she created a task force on on the representation of people in post-conviction, both capital and non-capital. It was Rebecca Hudsmith and I were the two token criminal defense lawyers on the committee of about 30, which was primarily prosecutors, judges from all three branches. And after about a year of hearings, Justice Knoll said that this matter was far more complicated than she had understood. Particularly, she focused on the issue of people who are non-capital cases, which are thousands and thousands of cases, as opposed to about 60 or so that are capital cases. And the Supreme Court Task Force said the first thing you need to do is you need to divide up the way you handle these into capital and non-capital, because the speed and nature and complexity of the cases is vastly different, and the non-capital cases do not have a lawyer. And the client cannot possibly do anything, as Mr. Marshall was saying, until such time as they have a record. And there have been work by Judge Shahardi and the clerk of courts to try to get records available to all people that are serving in non-capital sentences, and recommended that it go to the Law Institute for a study, who studied the matter for about 3 or 4 years and came up with a comprehensive plan that adopted in great part some of the Supreme Court's views, which were that capital and non-capital should be treated differently. Over my lifetime, I'm fond of saying that your definition of old changes over your lifetime, and I'm more of a trainer now than I am a litigator. I taught post-conviction law at Louisiana State University to prosecutors and to judges. I've been involved in many training programs, and it's very complicated, and it's very difficult to find people who are willing to do that work. And so while there's a lot of things in the bill that I don't think are a good idea, the thing that I'm here to tell you today is that as a person who will be involved in training defense lawyers and prosecutors and judges how to handle this, it's going to take some time. You know, many judges have never handled a criminal case, let alone handled a post-conviction case. It's a whole different ballgame. And so, you know, I appreciate the representative's changes on the timetables. I think that's a fair resolution of that, but I really think that you're going to see more chaos than order unless you give the judges, the prosecutors, and the defense lawyers an on-ramp and say, in a year, this is what the rules are, and this is how you have to train them. And so I'm encouraging this committee and to consider postponing the imposition of this until we've had a chance to locate, train, and qualify the people that have to do this work. I'll be glad to answer any questions.
You must have been thorough. There are no questions. Thank you. Yes, sir.
Good afternoon. My name is Gary Clements, and I am retired now, but for 30 years I did nothing but capital post-conviction work, except for about a year when I worked for the Federal Public Defender's Office. And I am here to basically point out to the committee that the Louisiana State Law Institute basically was tasked for many years with trying to grapple with the aftermath of when Justice Noel said that this was a complicated situation. So I believe, Jim, that was in 2010, roughly, when that examination took place. In 2014, I and several other people, including Judge Guy Holdridge, who would have been here today, was hoping to be here, but unfortunately is in Destin at the Judicial Training Conference that's going on there right now, the annual Judges Conference. And I'm here to provide a background by my participation in the Louisiana State Law Institute as a stakeholder. There were many people mentioned as stakeholders in this process, and I would submit that I do qualify, having done nothing but basically represent people on death row since I became an attorney in 1992 up till 2022. And I would just point out that 6 years of meetings. I drove up from New Orleans to Baton Rouge. Other people took a much longer route. And we went and discussed with representatives of the District Attorney's Office, the Attorney General's Office, judges, and we went through piece by piece the work of looking at the post-conviction statute. And to specifically address the issue that Mr. Bourne spoke about earlier, there was a bifurcation. They split it into two parts. They made a separate bill for non-capital post-conviction and capital, because they're really so very, very different for the reasons that he pointed out. And the upshot of that is that a final determination of a bill was put together in 2019. And the Louisiana Law Institute referred that to this august body, and in 2020, House Bill 223 by Representative Bacala put word for word everything that the Louisiana State Law Institute put into this. If you've never seen this before, I suggest that perhaps you should, I don't have copies of it to show it to you, but the fact of the matter is it's a 60-page bill. It has two parts. The first part is about 22 pages, and the rest of the 40 pages are the capital part. The first part is the non-capital rules and procedure, and the followed up by the capital procedure. And I would just like to point out that what they did is that in this process, what we did, and then passed on to you and was put in into House Bill 223 in the 2020 session, and in Senate Bill 109 by Senator Foyle in the 2021 session. They were basically identical bills. Unfortunately, something called the COVID pandemic took place, and a lot of things didn't get done in those days, so neither one of those bills was addressed. Fast forward to the point, but if you take a look at those bills, you'll see that the first line of them says, on the recommendation of the Louisiana State Law Institute. So that's the group that takes the time to do the homework, to put these things down. They don't expect everybody to do it. But what did they do? And I'm just going to give a real cursory overview. They put in step by step by step examination of the process and timelines, deadlines that never existed anywhere before. What they did not put in was a final date that everything has to be done by. But what they did, if you just take the parts that they did, it was well over a year in itself after attorneys would be assigned to the case and start working to file something. And once something was filed, it went into a hearing. And again, they didn't say that a hearing had to be done and concluded by X amount of days, because that's something that is very difficult to tell in advance. It's like telling somebody going into a trial, you've got 3 days to do this case. That's the state law now. That's really nonsensical, in my opinion. Maybe I'm just missing the point, but that's kind of what this bill does, is it pushes things. But what's the worst part is that in this bill, the current one that we're asking for a movement of 1 year past, is that everything will be done no later, everything will be finally adjudicated by July 1st, 2026. And that is simply illogical. To have that deadline on things, I know why it's there, and I think you all know why that date's there. It's to try to say that there will be finality, as it was brought up. But that's not, that's like blinking reality. That's like telling you all that you've got 30 minutes to decide how to do all these bills, and, if you don't get it done, then you're going to have to toss those bills in a trash can forever. That's what this is. Putting that kind of a deadline on here is illogical and doesn't make sense. And I can tell you, I'm speaking from experience, that it's not taking into account the fact that evidentiary hearings of themselves take from 4, 5, 6, 8. We had one case that had 23 days of evidentiary hearing, and that was a case in Baton Rouge here on one legal issue: whether the person had intellectual disability or not. The judge rejected everything. And that's supposed to be considered when mental retardation, as it was called back then. I was here, for the legislation that came in there, and it just said, the district attorney said, we would never bring a case against anybody who truly has mental retardation. And yet, here we had a 23-day hearing that was vigorously litigated on both sides. And the bottom line is that guy has been granted relief. He's been found to have intellectual disability and therefore excluded from execution because of his intellectual disability. And that is decades after the crime. The mental retardation bill didn't exist when he had his trial. These are just little things, and I'm not going to take more examples to tell you any other thing. I'm just saying that putting a hard and fast date sounds good. It's a great soundbite, but it doesn't make sense in the real world, and it's exactly like anybody here saying, coming up with an artificial deadline on something that you all have got. And it's as if during the pandemic, for example, when everything, was going crazy, somebody said, well, if that bill didn't come up that year and dealt it, that's it. Too bad, so sad. Things happen in the world, and we have to figure out how to deal with them. They're not going to be as tragic as a COVID pandemic, impact, but these are things that apply to you all. And there's no more emotional kind of a case than a death penalty case. Somebody say, that case has got bad facts. I never had a case that had good facts. None of them were nice. And does that, some people think that the defense attorneys are heartless, cruel beings that don't give a darn about victims' families, That's just not it. That's not the point. We have a job to do. The Attorney General has a job to do. The district attorneys have a job to do. The judges have a job to do. They need time to do their jobs. And that's what asking for an extra year is about. So seriously consider that,
Senator Barrow does have a question or a comment.
Yes, a lot has been said. It's a lot to try to unpack in all of that. But at the end of the day, I hear you as it relates to extending the deadline. And so that's something that I was working on, trying to see if we can get that language. And so the likelihood of this getting out of committee is very probable. And so what I will say, I'm going to ask the author if he would commit to maybe looking at extending that 1 year deadline to give everybody enough time to ramp it up. But the other thing that you mentioned was COVID-19 and the pandemic. And we don't know. I mean, that was something this world had never seen before. And I'm not going to say we'll never see it again. I hope we don't.
Right.
But if something like that happens with all of these tight deadlines, that brings up another concern that I had not even thought about until you mentioned it, in terms of them having to meet the deadlines and the benchmarks, because there's nothing that gives an exemption or extension if there's some extenuating circumstances.
Right.
Which that would be. I mean, nobody was in public. Nobody was interacting with each other and having meetings and so forth and so on. So,
If I may, just the Law Institutes put language in their proposals, which were both in the House and the Senate bills in 20 and in 21, to say for good cause an exception will be granted. That kind of thing existed. You know,
Okay.
it's just human.
okay. Well, I like the analogy that you using us, because certainly I think we can all identify in terms of like the timeline that we have, and if we are being given a tighter timeline to hear 2,000 bills, I think we know that some of that is just not going to be logically done.
Right.
Okay,
Except
thank
that in the cases of death penalty cases, it is literally do or die.
Yeah,
Our clients are going to die. And that's all I'll say.
Thank you, sir. Thank you. I appreciate y'all testimony.
Thank you for your testimony. We do have one more in opposition wishing to speak, Stanislav Moroz. If you could please, sir, come to the table and
Yes.
give us your testimony.
Good afternoon, Senators. My name is Stanislav Moroz. I am a law professor at Tulane University, but today I'm only speaking on behalf of myself and not Tulane or any other institution. I just want to make a few points. I echo what a lot of the other folks have said. One, you know, obviously post-conviction is a very complex area of criminal law. I teach to third-year law students, and when they come into their third year, they pretty much have never heard anything about post-conviction law. Most criminal attorneys, both prosecutors and defense attorneys, don't practice criminal law. And so it is a very technical area of law, and that is why I think the advice that the Law Institute has given before is very important to follow. I also want to point out and kind of elaborate a little bit that the vast majority of people who will be affected by this legislation are not people sentenced to death. The vast majority of people affected by this legislation will be individuals who do not have attorneys. Post-conviction, you're not entitled to a lawyer if you are not sentenced to death on post-conviction review. And what that means in practice is, you know, post-conviction is one of the first, is the first time you can raise certain very important constitutional claims. Prior to post-conviction, you're not allowed to bring in any new evidence into the record. So if you'd like to make a claim that there was important evidence that was withheld and not provided to the defense that shows that you're innocent, or if there was critical evidence that the attorney at trial didn't get because the attorney was ineffective, the first time you can do that is post-conviction review. And so I think sometimes folks think of post-conviction review as just another type of appeal, but it's actually the first time you can raise certain claims, and it is unique in that way. And this bill will have very significant effects, not just to people sentenced to death, to death, but also individuals who don't have attorneys and are navigating a very complex litigation environment. At most, individuals typically have what's called counsel substitutes or inmate counsel substitutes, who are individuals who learned the law while being in prison, and they work very hard, but they don't have the resources or training that most attorneys have. Like, they can't just go search the internet to investigate things. They can't go look for witnesses. They may only have a high school education, and they're trying to figure out one of the most critical, difficult areas of law on their own. So I just want to give that background, and then I just want to speak to some of the timelines that this legislation sets. And I want to, in terms of the timelines, I want to start by saying that I do agree that there are certain cases that, you know, move slower than they need to move, but this imposes a one-size-fits-all approach on these timelines in post-conviction cases, and it doesn't take into account the individual realities of each of these cases. And I think there has been some positive movement on the timelines, but there are certain provisions that, by my reading of the amendments, are still there and could be quite harmful. And then the effect of that is when we have these artificial timelines by which cases have to be concluded, it makes the cases a lot more likely to result in error. And if they result in error, that might mean that an appellate court or a federal court has to kick the cases back, and then we start from the beginning. And so the concern is just that this wouldn't even create a faster, more efficient process. It would create a more error-prone process. Just a couple technical points. My understanding is that the on-ramp issue has not been addressed in the amendment, so all that would need to happen is that, I can pull up the page, I apologize. So there's dates in paragraph D on page 7. That's what that effect. That's the part of the legislation that talks about what would happen to the currently pending cases. So if the committee was interested in creating a bit of an on-ramp, so folks could at least get up to speed and get ready for these cases, that would be the area of the legislation that the committee could look at. If all of these cases, and this isn't just the capital cases, again, this is all of the post-conviction cases that are pending now, and we just don't know how many are out there. Many of them are filed pro se without attorneys. If all of these cases have to be heard by July 1st, 2025, it could cause serious problems in the court system. It could cause serious problems for judges who are trying to address pretrial cases, murder cases, human trafficking cases, really, really serious cases, and they may not have the attention and time to be able to reliably adjudicate all of these matters at once. And so I would also encourage the committee to create an on-ramp. I'd also like to just discuss some of the how this bill would affect the timeline for future post-conviction cases with a couple of examples. So one thing that this bill does is it says that a judge has to do a preliminary review of everything of a petition within 30 days and decide whether to dismiss it. And it spells out that as part of this preliminary review, the court would have to decide whether the facts alleged in the petition are so contradicted by the record that the petition should be dismissed. That's nearly impossible to do for some post-conviction cases because some of these records are thousands of pages long. There can be many hours of video. There can be cell phone records. And so for a judge to do all that within 30 days will just lead to errors. Similarly, this bill says that once the court decides that a hearing needs to happen, there's 180 days to do a hearing. For a petitioner who's pro se, their first chance at getting a lawyer, the judge has a choice to give him a lawyer if they order a post-conviction hearing. So a brand new lawyer would be coming in and would be forced to learn the record, which could be thousands of pages, to meet with their client, to do investigation, to order additional records, all within 180 days. There might be some cases where that's possible, but there are going to be many cases where that's not possible. And so what I just want to say is, if the committee wants to move some of these cases along faster, I understand that, but I would I would soften the language at least a little bit to allow these timelines to be extended for cause if a judge believes that in a particular case more time is needed, or I would make these timelines into guidelines that a judge will follow as opposed to mandatory one-size-fits-all set in stone. Either party can already move a court to rule in an expedited basis, and if a court isn't ruling, can seek a mandamus, meaning seek a higher court to order the court to rule on something. So it's not as if we have no ways to resolve this right now, but I would just say at least create some flexibility for the cases that don't fit into the timelines in this bill. Thank you.
Okay, thank you. Okay, let's see. I see no questions for you. Thank you.
Thank you, Senator.
I think we have two more cards. I don't think he's said these. Elizabeth Powers is an opposed, present in opposition, but does not wish to speak. Bruce Riley is in opposition and is here and does not wish to speak. Is anybody else that had a red card that wanted to speak? Okay, I think we're through with those. I guess we can close on your bill.
Mr. Chairman, I have a blue card in, and I really didn't have a chance to make a statement. I answered some of your questions, but I would like to have an opportunity to say something on behalf of the bill.
That's
I think
good.
Mr. Walters may want to as well. What we heard a lot, Larry Freeman, Chief Deputy Attorney General, what we heard a lot here is let's delay this a little further. But let's talk a little bit about delay. How about Nathaniel Cole, who was convicted after a death and given a death penalty for the crime he committed in 1987. He's been on death row for 40 years. 40 years, and that victim and that family has not gotten the justice they deserve. Todd Wessinger committed an execution-style killing of an innocent young lady 30 years ago, and he's on death row for 28 years. Henry Broadway committed murder 32 years ago, and he's been on death row for 30 years. And we keep hearing about delay. What about that delay? What about the delay of justice for those victims, those families? Larry Roy, the Cheneyville slasher. I don't know, you didn't have a chance to see the family who came. The boy, he was 8 years old, had his throat cut. He can't speak. He came to committee to ask for justice 30-something years ago. And we're talking about delay. Let's delay it another year. Let's give the judge a chance to delay it. Let's give the attorneys a chance to delay it. Well, that's all they've been doing for the past 20 or 30 years, is delaying everything. Delaying everything. We've been paying, this state has been paying about $7.5 million a year to the Capital Defense Fund. In the past 10 years, I can almost count on one hand how many things have ever been filed in 56 cases. What are they doing with the money? What are they doing with the money? But they want another $4.2 million. And guess what? The state stepped up and said, we want to move these cases. We're willing to put up that money to do it. And I applaud the legislature for doing that. But let's not delay justice any further. Let's not delay this and delay that and give them more time. They have been working these cases for 30 years. If they're not ready to move the case, what have they been doing for 30 years, 20 years, 10 years? This isn't new cases. This isn't new capital cases that just got convicted. These are people that's been sitting there forever with the same attorneys working the cases. They should be more than ready to go forward. Either that or they need to be returning the money to the state that they've been taking all these years. So I appreciate you giving me an opportunity to make the statement, but sitting there, it just bothered me a lot to hear, let's delay it, let's give them a runway, let's give them a chance to get ready. They have been doing this forever. They're ready. The state's ready. The Attorney General's ready. The district attorneys are ready, and the courts are going to be ready. We're going to move the cases forward, bring justice and finality to the victims and their families. And look, if they're defendants who need to be released because they're incarcerated illegally or whatever, we need that to happen too. So it's going to cut both ways. But we can't just keep sitting around doing nothing.
I think we get the point.
Thank you.
Mr. Freeman, Senator Barrow does have a question. We want to try to, we're supposed to be on the floor here in a minute, so we do have a couple more bills. So, I'd like to try to wrap her up when we can. Senator Barrow.
Yes, Mr. Chairman. Assistant AG.
Thank you.
I understand some of your frustration. I mean, I'm not going to argue with you in terms of the timeline. I can't speak to that. I'm not an attorney. I'm not there. I'm not sure what's happening. I don't know why it took so long and why those cases have still yet not been resolved.
Okay.
But I think that you would agree that some of this may take a little bit more time to get them to get in place, because we know that they are short-staffed. They have been chronically short-staffed, not having the people that they need to be able to do this. And some of the things that are being asked to do here is a lot. I think it's only reasonable to ask for some extenuating time for them to get everything in place to do this. I know that y'all have been working very hard. It's my understanding that they have been working with the Attorney General to kind of work on some amendments. It almost sounded like it was kind of concrete that you were not open to having some level of runway, but I would think that y'all would think that it should require a little bit more time. We're talking about July 1. That's in less than 30 days.
Senator, I can commit as the bill author. I'm willing to work with everyone and look at it.
Okay.
I understand where the Attorney General's office is on it, but I have been very clear with everyone from day one. I've met with the Innocence Project at my office in my district several times. I've met with them multiple other times. I've had a phone conversation with them on Sunday afternoon. And so I can commit to you that I'm going to continue to work to make sure that this bill creates reasonable deadlines, but that deadlines are reasonable. I understand the nature of the issue. I understand what the Attorney General is saying as well, but I will commit to you that I will continue to make sure that this bill is the best posture and it does the best job to create the finality that we all want, but does not impair the rights of anyone who may have been wrongly convicted.
And I really appreciate that. And if there could be some language, and you and I can talk about that, where it may offer some level of flexibility in the event that something happens. We don't know. We pray that nothing does, but I mean, even a hurricane, how can that impair, especially if it's something like a Katrina, where all of our lives was turned upside down, at least for a good year and a half before I felt like there was some level of, stability. And then the other part that I would just add is just, some of the people coming into the public defender's office, a lot of these folks don't have experience. I served on the commission. I heard a lot of the traumatic things that they are going through as well. But I appreciate your commitment to continue to work on the bill.
Thank you.
Thank you, Mr. Chairman.
Thank you, Senator Barrow. I believe all the cards have been read in. Are you concluded with your closing?
Yes, Mr. Chairman.
The board is clear. There are no other questions. Pleasure of the committee.
Well,
Pleasure of the committee. We're done with this bill. Okay. We had two motions, but I'm going to take Senator Miguez. Moves to report House Bill 675 with amendments. Is there any objection?
I'm not going to object.
Okay. Fair enough. There being no objection, that bill will be reported with amendments. Thank you, gentlemen.
Thank you, Mr. Chairman.
Thank
Senators.
you, everybody, for your patience.